Cool. Islam, greetings. I hope you brothers and sisters can hear me. Let me cut this down. All right. This video is basically, first and foremost, I say Islam, greetings. My name is Brother Messiah Ali Bey, and the topic today is the continuation of the affidavit in support. And we talked about before, as far as a status affidavit pertaining to those rights that we have. All right. So what we're going to do is continue on, and this is for educational purposes only. As you guys know, I'm not an attorney. As you also know, I'm a paralegal. Nevertheless, the purpose of this here video is so we can continue on further. And the last time we went over um, the document itself. However, as we continue on later on, um, I'll find some kind of a way to build a Zoom because I need comments, statements, and opinions. When I put the video up in the YouTube, I want comments, statements, and opinions because I know there's a lot of diversified community out there of Moors that got various different ways of doing what they do. Nevertheless, um, what I know is what I went to school for, and what I went to school for. When I go to court, it works as far as procedures, application, style, and strategy. Strategy means everything with this here because, like I said before, an affidavit basically by itself don't move a court. A notice with the affidavit can move the court because now you want the day to be heard, but you want to support it with some law behind that, which will be your memorandum. What's important about this, where we at now here? Remember, we talked about we had 5 points that I was bringing up inside this document here. One that I was stating that I'm not the person described in the prosecutor's charging instrument, and that the charges pertain to one that is the subject of the 14th Amendment or subject to the enactment of H.R. 48. That's House Resolution 48. Mr. William Bingham, if you Google it, Mr. William Bingham is the congressman that proposed this bill to Congress that became a law. Also, I want to clear up the last time I made mention of Article 14 in the Moroccan Treaty that Moors wasn't supposed to be made slave. That's the wrong article. It's Article 16. Article 14 is for uh, most favored nations clause. So I want to clear that part up there. Getting back to this here. So now, as you noticed before when I was discussing it, I had 5 different I would call them affirmative defenses. You can make it affirmative defense, or you can make it as an affidavit. All right. Don't want to change the course here, but as we go further into this, we're gonna go back to the affirmative defense with this status here. Versus an affidavit of fact. Okay, what's the difference in the strategy? Okay, however, at this point, we got 5 points, and in each 5 points, we got 5 subdivision sections that got to go in the memorandum of law. What I mean by that is that 1, it says I am not the person described in it. So now, when you go to the memorandum of law, it's the first thing is the question presented to the court. Okay, because now the memorandum is establishing what they consider settled law. So the question being presented is 1, and then you got to give them the answer. Should Moors be subject to House Resolution 48? Answer: no, because under the term that was used within the creation of the statute, the word Moor was never included. Okay, that's my short summary of my short answer, right? So that answer is for that part right there. Then I got another subsection coming in. Such presumptuous bubble is burst by the support of evidentiary state records adopted by the House of Representatives of Pennsylvania, recognized as House Resolution 75 of 1933. before the Society of Moorish Americans, which the jurisdictional challenge in this case illustrated it as an exhibit as proof of status demonstrated in the jurisdictional challenges pleadings. Now that's point two. Now we got to get the subsection for that regarding the presumptuous belief that the question presented. Most likely, let's say we're in does resolution 75 conflict with House Joint Resolution or the 14th Amendment? The answer is yes. You can give a short statement and use it out of the Resolution 75 if you wanted to. But there's a whole host of different ways. We're just touching the tip of everything to give you an idea of how to, when you're filing your papers, what's expected from you, what's expected of you, and how it must be, from a Moorish perspective, creative writing. So now we have point two, point three, point four, and we have point five. Each one of them is a subsection. And also, I want to give you some more information. As you know that I'm talking about affidavit in support, I'm asking you guys to um, Google any term, order to show cause, okay? But do it in YouTube because you're going to get a document and a video. You could do affidavit in support as well, so you can see what is going to. It's a bland or blanket statement of how something would be, but we coming from a Moorish perspective, so this is what changes things. Not that we're not using the law, we are, but it changes things in regards to how we're defending ourselves. So you can go there, go to YouTube and look for order to show cause. Look for affidavit in support. Um, look for a memorandum of law. They're going to lay that out the same way I laid it out for you and show you that in the memorandum, okay? And this is the same thing that's going to happen in this paper that we have here too. Remember I said behind this here, point 1, 2, 3 through 5, you got to give question presented, okay? Then you got to give an answer. So on each subject that you're talking about inside this paper, you got to give that point. Remember I told you IRAC, issue, which is question presented and answer, ruling, okay, how the courts ruled on a similar principle matter regarding about this issue here. Analysts or reasoning. You can even have reasoning and analysts in terms of what the court used to give its determination by the historical cases or other modern situations that they use to bring about the balance of the law in their analytical approach and in reasoning to make their ending as far as the conclusion that you will close out in this manner right here. Okay, so you got issue, reasoning, analyst, and conclusion on each point. So you got 5 points here that you got to do 4 things 5 times. It should be thought out. It should be thoughtful. Why? Because that's the law that you're putting down now. Okay, that's where the law will come in that you're putting down now. Now, for an example, as you do remember, if we go back to the other tape, we talked about Ellen versus Valkenbrown, which was the purpose of the 14th Amendment. That would go into your memorandum of law. Let's say you could use that on point number 1. You would be able to use that on point number 2. You would be able to use it on point number, against, as far as contrary evidence. Point number 3, point number 4, or 5. You can use that either place in that area there. Okay. However, but we as we stepping up in our argument, we go into the treaty area as well. So now you have to change your position because actually it's in point number 4. We don't just go into Resolution 75 and Prophet Noble Drew Ali, but we go into articles of the Moroccan Treaty by which the violation had occurred. So now that takes it to another direction. Okay, so we got in point 4, we have not just point 4, but we got point 4 and 4A. So we have a subdivision inside that one. Because we're talking about Resolution 75. Actually, we should have A and B. We're talking about Resolution 75. We're talking about Prophet Noble Ali and establishment of the Moorish Science Temple. Okay. And then on the other page, we're dealing with the Moroccan Treaty of 1787, 1836. So we really got 3 subdivisions inside point 5. 5A, B, and C. So we'd have to lay that out like such. However, law is very specific in order for us to get to the point that we're trying to address. And what's really important that you must know is that you must speak to the audience that is going to be reading this paper. Whether if it's a prosecutor, you got to be speaking the same language with him. Not his language, but the same language. You're talking to the judge, the same language got to go down again. Either one of them. Because it's a legal instrument. So it's a language of itself. This is why we all get a Black's Law Dictionary. Because the Black's Law Dictionary is the equivalent language to the legal jargon that we need to speak to prosecutors, lawyers, district attorneys, attorney generals, judges. This is their language, the legal field's language. So we have to have that dictionary, and we have to get used to as far as get a glossary of terms. So as we're talking, it's the same as speaking English. You got a glossary of terms. This is how we're able to speak sentences and get our points across. The same thing would be in Spanish. All right, so it's getting that stuff together in order for you to convey your message and to get back a suitable answer. Okay? So it's very important that we know this part right here. Nevertheless, like I said before, when we was in these those sub issues, those subsection issues, we also have, like I told you before, the Judiciary Act of 1789, Section 25. In fact, I'm gonna stop the video real quick so if I can find it, and because I want to be able to highlight that point to you. Hold on for 1 second.